the growth of our firm in this field is similar to the advent of employment law and how it all started. There was a period of time where there was no such thing as employment law. The reason being that there were no laws that required the attention of lawyers around the country. It actually started in 1990, 1991 with the advent of an amendment to the civil rights law. At the same time, as I said, the federal law was broadened to provide for money damages, for the right to a jury, and so you have two laws that were now explored and that were now being used. On top of that, in the 1990s, 1991, the New York City Commission, the governing body of New York City, passed a law referred to as the New York City Human Rights Law. Now, in New York, we had three laws under which we could proceed in an employment case. We had a case that was referred to as Thorson against Penthouse. At that time, my daughter, sitting to my right, Schwartz Perry, who had been practicing up in Boston, joined our firm and became involved with us in the prosecution of the Thorson case.
Our client was Annika Thorson, and she worked for Penthouse magazine. She also had a personal relationship with Robert Guccione, who was the founder of Penthouse magazine. She worked for him. She posed for Penthouse. She was in the movie Caligula. She performed the oral sex scene in Caligula, and one of the strongest defenses I've seen was in that case where the defendant tried to argue that because of her past, she also had some issues in her own personal past when she was younger. They sort of argued that she was immune from being sexually harassed, and the trial court completely and totally disagreed. It doesn't matter who you are. It doesn't matter what your past is. Sexual harassment is sexual harassment. And in that case, Guccione forced her to have sexual relationships with his business associates to further his own business relationships. And the trial court absolutely disagreed with the defense that they raised. The case is also very remarkable because she was able to prevail on her testimony alone. There were no witnesses. Sexual harassment is not done in a conference room in front of other people. It's done secretly behind closed doors. And the court very strongly in its decision said that you don't need a witness to sexual harassment. So that case really stands for a lot in this field.
A short time thereafter, we were the firm that instituted one of the first actions under the New York City Human Rights Law, which was a case cited as BRCA. And that was the case in which the law was attacked as being unconstitutional, the claim being that the federal law and the state law had preempted the field, and we argued in behalf of the New York City law.
The BRCA case was a sexual harassment case. We represented a female associate in a law firm who had been sexually harassed by the senior partner. And the very remarkable thing about the case was that there would have been no BRCA case if the law firm had prevailed in getting the law declared unconstitutional. So by winning the motion to dismiss the case, we were involved in having probably the broadest city human rights law in the country validated. And Ms. Bracker's case was permitted to proceed, and many hundreds or thousands of other cases have been brought under that law.
What's interesting about this field in particular is that there's no clear evidence about any of the actual issues that matter. There's no documents talking about discrimination. There's no testimony you can get to prove that there was retaliation. It's all about people. And what you've really got to do, and what I found absolutely fascinating, was getting a jury to recognize that they're not seeing the whole truth, that they're not going to see. No one's going to tell them what actually happened from the company, because it's not in their best interest to do that. So to really get underneath the story, to get underneath the case, and to expose the underbelly to a jury and having nobody to talk to show them what happened, other than the plaintiff, but trying to get from the company and to ask questions to really get to the bottom.
You're not going to come in with written documents or a smoking gun. Everything is done clandestinely. No one passes around a memo saying, let's get rid of all the old people, let's get rid of the women, let's get rid of people who are a minority. You don't find that. And a jury, therefore, has to be able to use their own life's experiences. The juries, we have found, become very, very involved because they can sense the significance of what they're asked to do.
The thing that brought me to Schwartz Perry is, I was right out of law school. I was very idealistic, and I still am. And I was looking for something in human rights and civil rights, which when you're a new law grad seems very unattainable. It seems like 1 in a million people get to do that, the fighting the good fight for the people. And I saw Schwartz Perry listed in a job listing and went to the website, and I was completely blown away. The major cases that you heard Mr. Schwartz and DeVita speak about, I couldn't believe it. These were cases that I had read about in law school or had been alluded to, and they were sort of the major civil and human rights cases, and I thought, I can't imagine working for a place like that.